Okay, Counsel, whenever you're ready.
Good afternoon, Mr. Arbitrator. My name is Austin Seah, and I'll be speaking on behalf of the first appellant, Mr. Landed, on issues A and D. My co-counsel, Mr. Mark Peter, will be speaking on behalf of the second appellant, Ms. Tangs, and he will address issues B and C. We respectfully reserve 1 minute for rebuttal. Mr. Arbitrator, this case is about removing the taint of illegality and discrimination so that justice can be done. The gold medal is Mr. Landet's, not as an indulgence, but as a matter of right. He secured it on the field of play, driving his team's comeback in the finals of the qualifying games. He complied with the rules, for the substance blue bat was absent from the prohibited list governing both the qualifying games and the global games. And yet, he faced a tribunal whose majority was inherently biased against Ms. Tangs. Their ties with Ms. Tangs and their subsequent non-disclosure of such ties demonstrated that they were unable to be independent and impartial. With that, I make two submissions on the first issue and second issue. Firstly, the GDC's quorum was biased in coming to a decision. Mr. Douglas and Ms. Farina are not independent and impartial arbitrators of the GDC's quorum. Secondly, the GDC had erred in finding that Mr. Landed had been liable for doping. Bluebet is not inside the WADA list. Turning to our first issue, we understand that Mr. Landed is challenging the constitution of the GDC, alleging that there was biasness due to the appointments of Ms. Farina and Mr. Landed. Ms. Farina and Mr. Douglas. To determine the criterion of arbitrator, the applicable rule is that from Rule 33 from the Code of Sport related arbitration, hereinafter the CES Code. Rule 33 states that every arbitrator shall be and remain independent and impartial of the parties and shall immediately disclose any information which may affect his or her independence with respect to the parties.
So, Counsel, earlier you relied on the Constitution, right? And then you suddenly spoke about the WADA code. So, what is the relationship between these two, actually?
Mr. Arbitrator, are you alluding to the issues of issue D regarding the doping, or are you talking about the CES code with relation to the issue of independence of an arbitrator?
I mean, both, because right earlier you spoke about the Constitution, right? So I was assuming that it will be in relation to this issue they're talking about, the independence. And then you suddenly cited the CAS code. So I was wondering if you could clear it out for me because the legal basis of my powers are important. My
Hmm.
jurisdiction is important. So if you could address maybe these two issues, that would be great.
Understand, Mr. Arbitrator. On the first issue regarding the CES code has been cited before by this court on multiple occasions, such as in the case of International Olympic. It has been cited in many cases of the CS before to identify and interpret the rules relating to what a CS arbitration should be. And regards to the WADA code, it specifically is noted at Regulation 13 of the moot problem that this court can apply the WADA code and should be adhering to it. Turning now to the issue of independence. To determine what amounts to an independent arbitrator, we can look to case law. In the CES 2006 case of FCV and FCS, decision of challenge, it noted that strong or negative emotional bonds through relations between an arbitrator and one party or its counsel indicates a lack of independence. Turning first to Ms. Farina, she has a familiar relationship with Ms. Tangs as seen from the moot problem. She is Ms. Tang's cousin sister, which essentially means that is Miss Miss Farina is Miss Tang's cousin. This kind
Where
of
can I
person,
see that, Counsel?
you can see that at you have to move problem. Para 28 of the moot problem, Mr. Arbitrator.
Okay.
Thank you, Mr. Arbitrator. Apologies, having some issues with my computer. This kind of personal connection, this kind of personal connection could easily be characterized as a strong emotional bond between family members, which can indicate impartiality on the part of an arbitrator. Miss Farina also provided extra on-the-side coaching to Miss Tangs and prepared them for the upcoming qualifying games. This demonstrates a professional relationship where Miss Farina had invested time and effort into Miss Tang's success prior to adjudicating on a dispute involving her. Turning now to Mr. Landert. 6 months prior to the case, he was engaged to have a one-time special and personal training session with Miss Tangs. This shows a professional support of Miss Tang's team. Following the session, their relationship eventually got closer, with both parties being in contact since. Their ongoing contact and close relationship constitutes a continuing bond extending beyond a single professional engagement. This is further bolstered by the fact that Mr. Douglas has participated with Ms. Tangs in fan meetups. Going beyond a simple role as a coach, this public association further solidifies the factual existence of a positive and strong bond that lasted 6 months till the very date of the hearing.
Counsel, you cited a lot of facts to me. Could you point me to where in the problem itself or where in the record itself I can find these?
Apologies, Mr. Arbitrator, I've not noted them down at the moment.
Okay, go on.
In the alternative, Mr. Arbitrator, there is no need for actual finding of biasness in our case. In fact, the idea of a perceived biasness is enough. And this has been relied on in the 2020 case of Sanyang and World Anti-Doping Agency. In that case, the panel's chairman, Mr. Franco Frattini, had posted a wide range of tweets against Chinese nationals. One such example of this tweet was that this yellow-faced Chinese monster smiling while torturing a small dog deserves the worst of hell. Shame on China pretending to be a superpower and tolerating these horrors. This tweet, amongst a pattern of other tweets, shows that Mr. Frattini was actually biased against Chinese nationals. In the case, even though he wasn't actually biased to Mr. Sanyang itself, it suffices that a reasonable third party will understand these tweets to infer Mr. Frattini's impartiality.
But in our case, are there any such tweets or any such communications which can convince us to say that, hey, from an objective third person view, that is really not impartiality, not partiality, or rather partial. Yeah.
That's precisely the case, Mr. Arbitrator. There is no facts that there was an actual bias that arise. However, we have to look at the relationship that I mentioned earlier. The core of it is that there's a presence of a familiar relationship between Miss Tangs and Miss Farina, and this is coupled with a close extended personal relationship between Mr. Douglas and Miss Tangs. Essentially, the GDC's quorum has a two-third majority with relationship with Miss Tangs, and hence, from a third-person perspective, there's objective biasness towards Miss Tangs. Unless I may be of further assistance on the first issue, I will turn now to issue D. Our submissions for issue D are structured in three main arguments. Firstly, Rule 12 of the qualifying games should not be applied as it is overly broad and inconsistent with the WADA code, and a finding of a doping violation under the GDC's own rules is unfounded. Secondly, blue bat is not a prohibited substance under the WADA code, and liability cannot attach to unlisted substances, save in exceptional circumstances. The GDC's enforcement of its anti-doping rules had also violated the principles of legality, due process, and legitimate expectation due to clear notice. Turning to our first argument, we note that the WADA is the exclusive standard for doping violations. Rules 7 to 13 of the qualifying game rules clearly provide that doping is defined by reference to the WADA code and prohibited list. Accordingly, the WADA code forms the exclusive and mandatory benchmark for determining anti-doping violations, mirroring the structure of Olympic Charter Rule 44, which makes adherence to the WADA code obligatory in our case. Secondly, Rule 12 of the GDC's rules is inconsistent and ultra-virus. Rule 12 defines a prohibited substance as any substance or method contrary to the spirit of the sport. This vague catch-all provision is inconsistent with the clear reference of the WADA code at Rules 7 and 13.
Furthermore, what does Rule 7 and 13 say?
Rule 7 defines doping as the occurrence of violations set forth in the WADA prohibited list and the WADA code, while Rule 13 instructs athletes to refer to the WADA prohibited list for the list of prohibited substances. The the broad scope that the GDC has seemed to impose in our case has been rejected by this court before in the 2004 CAS case of Maria Louisa Kelly Williams. It noted that the catch-all provision of other chemical substances with similar chemical structure cannot be construed to mean every stimulant, which is precisely what Rule 12 of the qualifying games seek to do.
So in that case, what are the specific wordings of the catch-all phrase provision?
The catch-all provision in the Mr. Arbitrator, are you referring to the case of Maria?
Yes, the case that you're relying on.
The catch-all provision was that other chemical substances with similar chemical structure. So in that case, the appeal centered on the fact that they wanted to include a wide scope for this. And in paragraph 25 of that case, it was noted that such an interpretation would not pass the test of clarity and predictability. Examples of other stimulants, such as nicotine and caffeine, all fall under the interpretation of Rule 12 in our case, and yet have not been banned by the CAS. Therefore, an extremely restrictive approach must be taken in interpreting Rule 12, and it must be read together with the WADA guidelines. Furthermore, CAS jurisprudence confirms that sporting bodies cannot expand doping rules. In the 2011 CAS case of USOC and IOC, noted the Osaka rule case, the IOC's attempt to impose additional sanctions beyond the WADA code was held invalid because the Olympic Charter had already made the code mandatory and to be the one to be relied on. Furthermore, the CAS case of 2010 involving WADA and BOA, the panel has struck down the British Olympic Association's lifetime Olympic ban as inconsistent with global harmonization. Similarly, the GDC's use of Rule 12 to create its own spirit of the sport test was ultra-virus. And therefore,
Counsel, I understand that there are a lot of CAS cases, but I have two questions. So the first question is whether I'm bound by those cases, because you say it's this court, but I did not sit on those courts. That's the first question. The second question is, what is the law governing interpretation of statutes or legislation or regulations in those cases as compared to our case?
Mr. Arbitrator.
Mr. Arbitrator, yeah.
Mr. Arbitrator, in response to your first question, we do acknowledge that CAS is not bound by its previous decisions. However, the CAS must ensure that its rulings are consistent. There is a difficulty in ensuring that a ruling is not, the difficulty in ruling separately from other cases will mean that this court will be unsure as to its position on a certain issue. Furthermore, that is consistent with the idea of lex sportiva. Turning to your second question, Mr. Arbitrator, with regards to interpretation, the CAS sits pursuant to Rule 28 of the CAS Code. Its seat is in Lausanne in Switzerland. And pursuant to that, this court has relied on various Switzerland cases as it is the seat in which this court sits in. Furthermore, our CAS cases that we have cited is precisely heard in Switzerland and hence can be relied on by this court.
So is our seat in Switzerland today, or is it based on some country? Other country, yeah.
Mr. Arbitrator, our seat is in Malaysia today, but that doesn't preclude this court from citing Switzerland cases in our case.
Okay, so maybe a further development of this question, because you keep saying that the seat governs so and so, but my impression is that the seat governs the rules of the arbitration itself. Whereas my question is, it pertains more to the substantive law that governs, say, the regulations or perhaps a contract, if you get what I mean.
I'll refer you to a lex arbitri, which is the law of the state in our case, which allows this court to actually rely on our past cases to interpret certain issues. Mr. Arbitrator, I note my time, and unless I may be of further assistance for both issues.
No, thank you very much.
Thank you, Mr. Arbitrator.
Mr. Arbitrator, members of the tribunal, my name is Mark, appearing on behalf of the appellant, Ms. Tanks. I will be speaking for 15 minutes on issues B and issues C. I will address the second issue in these proceedings, whether the Games Disciplinary Commission had erred in allowing the tribunal to be seated in South Lankaland. Our submissions is that the tribunal constitution was fundamentally flawed. The seat departed from the CAS code of default, of Lausanne without the valid consent, and in a way that gave rise to both the actual and apparent unfairness. I will structure my submissions in two parts. First, I will outline the legal framework, the CAS code, the SAMCO regulations, and the qualifying game rules. And second, I will turn to the relevant authorities and apply those principles to the present case to show why a tribunal seated in South Lankaland cannot stand. Mr. Arbitrator, the CAS Code Rule 28 sets Lausanne, Switzerland, as the default seat of arbitration, unless the parties have clearly agreed otherwise. This rule is not a matter of administrative convenience, but it's more to safeguard neutrality in the international sports disputes. Lausanne was deliberately chosen as a neutral venue, detached from the influence of any sports or federation or the host nation itself. Next, SAMCO Rules Regulation 19 incorporated the CAS code into these proceedings. That means that Rule 28 is not optional here. It is binding on this tribunal unless the parties have generally agreed otherwise. Now, Qualifying Games Rule 21 to 23 allows the disputes to be heard in a country where the tournament was held, where it is reasonably practicable. However, those provisions must be interpreted consistently with the overarching principles of lex sportia. Now, lastly, the lex sportia is the body of principles developed by CAS and other arbitral tribunals, which makes clear that the arbitral seat must be neutral and must not even give the appearance of home court advantage. Thus, even though the qualifying game rules reference the host country, that reference cannot override the CAS code's safeguard of neutrality, nor the fundamental principles of fairness embedded in the lex sportia.
Counsel, just a point of clarification. You mentioned SAMCO rules.
Yes,
Rule number 9. And that it relates to these seats, you're saying? Or did I hear wrongly? Sorry.
Your Excellency, I mentioned SAMCO Regulation 19.
19.
Your Mr. Arbitrator, yes.
Right. But this SAMCO regulations refers to some fictional mood regulation somewhere, and we are not in a mood, right? We are in an actual arbitration. So are you sure we should be referring to SAMCO regulations?
Mr. President, I apologize for the inconvenience and the confusion caused by me. We will get back to you on this issue right after. We will get back to you on this issue.
Right.
Rule 28 fixes departure from the default seat was improper, and Rule 28 fixes Lausanne as the default seat of arbitration precisely to ensure neutrality. In Motzilem and FIFA, paragraph 4 to 6, the professional footballer challenged the disciplinary sanctions, and the tribunal explained that the seat determines lex arbitri, the national law governing the arbitration, and that the neutrality of the seat is essential to fairness. The panel in Motzamel emphasized that Lausanne's neutrality as an anchor to fairness in disputes between international athletes and governing bodies. By contrast, the GDC's unilateral designation of South Lankaland, which serves at the Federation's headquarters, abandons this neutrality anchor and compromises procedural integrity. Now, second point concerns the appearance of biasness. In Muttu, Peshin, and Switzerland, the court explains that impartiality must satisfy not only the subjective test, but also the objective test, whether a reasonable observer would perceive this tribunal as an independent tribunal itself, which is seen on paragraph 139 to 143. Applying the case principle here, the seating of the tribunal in South Nagaland inevitably creates an appearance of partiality because the GDC is institutionally tied to the organizing structure of the global games. The local law administrative staff and the facility belongs to the same federation overseeing the disciplinary process.
But why shouldn't GDC choose a seat which is, nearby, as compared to having to travel all the way to Switzerland, just to arbitrate some dispute? I'm
Yes,
sure
sir.
it's not cheap, right?
Yes, Mr. President, I understand your concern. But in this case itself, the seat was not chosen nearby, but rather chose at the point where the HQ is situated at. So that is exactly what we are what we are contesting in this matter, that the seat could have been chosen to any neighboring country, but rather the GDC decided to host the disciplinary tribunal in the HQ of itself, which creates the apparent biasness. Going forward, the ECTHR in Muthu and Peshchin at para 182 further stressed that the transparency, including the public scrutiny, is vital, where an athlete's reputation is at stake. A tribunal convened under the shadow of the respondent's administrative headquarters cannot meet the transparency standard. Also, I would like to note that the Muthu Peshchin case themselves were athletes who went to CS proceedings and then appealed to the European Courts of Human Rights under Article 6, subsection 1, claiming the denial of a fair trial. The decision therefore arises directly from the CS framework and is highly persuasive in this.
I mean, Counsel, now that you mentioned that that case has involved the European Court of Human Rights, I'm a bit concerned.
Yes, sir.
First, because I don't think we are anywhere near Europe. That's the first point. And second, being that Europe is European jurisdictions are very much known for their strong human rights focus, which Asian jurisdictions legislation doesn't have such a strong focus. So why should I follow that case?
Your
Do you have
Excellency,
other cases?
we do, Your Excellency. I have another case, which is the Ali Reza and the Turkish Football Federation, as seen on the paragraph 212 to 216. The principle was made explicit that the justice must not only be done, but also must be seen to be done. Even the standard of appearance is fatal. The standard of appearance of bias is fatal. The tribunal in South Nagaland fails the standard of apparent impartiality. Mr. Arbitrator, for all these very reasons, the appellant respectfully submits that the tribunal was improperly seated in South Nagaland, and we ask the decision to be annulled and that the matter to be remitted to a tribunal seated in a neutral forum, such as Lausanne, in accordance with the CES code and the SAMCO regulations and the principles of lex sportiva.
So can this court actually go on to decide on the merits that you're asking for right now, rather than go through another round of arbitration?
Mr. Arbitrator, yes, this court can escalate this matter to the court to the CS court which is situated in Lausanne, Switzerland.
I thought I am the CAS court. I'm very confused now.
Mr. President, I would like to further explore and ask, would like to clarify, as earlier you mentioned that the SAMCO regulation. Mr. President, I will have to get back to you on this matter. I apologize for the inconvenience.
Okay, sure. I mean, I don't really think it's an inconvenience. It's more a matter of, do you guys choose me as the arbitration panel to decide on this or not? But yeah, go on.
Mr. Arbitrator, now I will be moving on to the issue C, which is whether the GDC had erred in declaring Ms. Tanks ineligible to participate in the games. Rule 3 of the qualifying rule games specifies that the Rule 3 of the qualifying rule games is exhaustive and clear, and it has been unfairly applied. In the case of CAS 2008-317, para 18, the tribunal had declared that when the rules are unclear, but not so unclear that enforcing them would violate the requirement of qualitative legality, it will interpret any uncertainties against the party that formulates such rules. In practice, normally, in the present case, the GDC violated CAS jurisprudence by acting outside of its scope of the powers, ultra vires, by essentially rewriting the rules set forth by the qualifying game rules, thereby acting as a rule maker itself. The GDC tribunal held that at paragraph 33 of the compromise, that Ms. Tang's being a dual citizen was found to be ineligible to participate in the games as she was not 100% Asian citizen. CS has emphasized that it is not a rule maker. CS cannot rewrite but can only interpret rules set forth by the sports authorities in light of the general principles of law, which was seen in the paragraph 33 of the 2009 case of Telecom Egypt Club and EFA. The ordinary meaning of Rule 3, subsection 1 states that an athlete is eligible if he or she is a citizen or permanent resident of the country in Asia. It does not mention sole nationality, exclusive nationality, or a requirement of being 100% Asian citizen. GDC had no right to rewrite the rule. In doing so, it acted in a discriminatory nature against Ms. Tanks merely because she held dual citizenship. Ms. Tanks meets the criteria under Rule 3, subsection 1, as she is indeed a citizen of Durrania. This citizenship was validly obtained by Durrania. Furthermore, at paragraph 32 of the compromise, she has domiciled in the country for 9 years. She also submitted the proof through pictures and documents. The GDC did not take this into consideration when it erred in its decision. Therefore, we submit that the GDC acted outside of its scope of its powers by rewriting Rule 3, adding that the requirement of being 100% Asian citizen. Now, moving on to the second submission, which is a dual consistent recognition of GDC. In CAS, PRABF, and US baseball case, the tribunal held on paragraph 1 that each country has the right to determine its own rules as to nationality. No country may dispute such right. The Olympic Charter recognizes that individuals may possess 2 or more nationalities, and at paragraph 2 of the case itself, in circumstances of the dual nationality, the choice of the National Olympic Committee, NOC, for which the athlete wishes to compete under is a matter for election by the athlete itself. In the event that the athlete has not competed in either such competitions for any of the 2 countries, he remains free. Therefore, elect for which one of the 2 countries he wishes to play for. In the present case, it is crucially important to recognize that Ms. Tanks had the right to elect which country she played for. Therefore, this was not a decision for the GDC to rule upon. At page 9 of the CAS case 9413, the panel said that having a dual nationality of US and Puerto Rican citizenship remained free to elect which the 2 countries he wished to play for. The claimant had not competed in such competitions for Puerto Rico nor for the United States, and it might have been otherwise had he played in such competitions. Whereas in the present case, at paragraph 32 of the compromise, she had not represented her birth country, Kyrgyzstan, and an oceanic country, and had identified herself as a Durranian citizen. A voluntary election of the represent Durranian under the rules of the Olympic Charter should be respected. This was a choice open for Ms. Tanks to make under Rule 41, Bylaw 2 of the Olympic Charter, as well as Rule 3 of the qualifying games. Therefore, the GDC had no right and erred when it overruled Rule 41 of the Olympic Charter, which recognizes an individual may possess 2 or more nationalities. Mr. Arbitrator, now we conclude that both Issue B and Issue C strike at the heart of the fairness of sport. Issue B of the GDC's decision to seat the tribunal in South Lankaland, the headquarters of the very federation overseeing the proceedings, undermine neutrality. As held in Muslim and FIFA, Muthu Peshin, and Ali Raza, justice must not only be done, but must seem to be done as well. By departing from Lausanne, without genuine consent, the GDC created an appearance of biasness and failed to uphold the principles of lex sportia. And on Issue C, the GDC exceeded its powers by rewriting Rule 3, to require that an athlete must be 100% Asian. Seah's jurisprudence in ANS Telecom Egypt and PRABF baseball makes it clear that the sporting bodies only interpret rules. They do not invent them from scratch. Ms. Tanks, as a lawful citizen of Durrania, was entitled to compete and freely elect the nation she represents under the Olympic Charter. Accordingly, we respectfully pray that the tribunal allows both issue B and issue C, declaring that the tribunal seat is invalid and affirming Ms. Tang's eligibility to restore the fairness, neutrality, and the integrity owed to all the athletes. Thank you.
Okay. Next.